Hello everyone. In this video, we are going to learn about caveat emptor. In case of sale of goods, the doctrine of caveat emptor means let the buyer be aware. When the seller displays their goods in the open market, it is for the buyers to make a proper selection or choice of the goods. If the goods turned out to be defective, he cannot hold the seller liable. The seller is no way responsible for the bad selection of the buyer. The seller is not bound to disclose the defects in the goods which he is selling. It is the duty of the buyer to satisfy himself before buying the goods that the goods will serve the purpose for which they are being bought. If the goods turned out to be defective or do not serve his purpose, or if he depends on his own skill or judgment, the buyer cannot hold the seller responsible. The rule of caveat emptor laid down in the section 16, which states that subject provisions to the of this act or any other law for the time being in force, there is no implied warranty or condition as to the quality or fitness for any particular purpose of goods supplied under the contract of sale. For this, certain conditions are to be satisfied. Let us see what are the conditions to be fulfilled. The first condition says that if the buyer has made known to the seller the purpose of his purchase, and the buyer relied on the seller's skill and judgment, and seller's business to supply goods of that description. If these conditions are fulfilled, then the contract of the rule of caveat emptor applies. Let us see the example to clear about this rule. If a person so sold goods to B, a goat, and when B buys the goat and it is joined along with his other goods, the B doesn't know that the goat is infectious. If, without knowing this goat, if it is mingled with other goats in his groups, the other goats are also being infectious. So, in such a case, B doesn't aware about the infectious goats in this example. In this case, the caveat emptor applies. And let us see another example. If A wants to purchase a horse from B and A wants to purchase the car for the purpose of riding and it is not disclosed to B, and this horse is meant for carriage. A doesn't disclose this riding and B doesn't disclose it's meant for carriage, and A doesn't disclose the purpose for which he wants to buy the horse, and B doesn't want to disclose the purpose of this car. So in this case, the rule of caveat emptor applies. For this rule, there are certain exemptions for that. The first exemption is about fitness as to quality or use, where the buyer makes known to the seller the particular purpose for which the goods are required, so as to show that he relies on the seller's skill or judgment and the goods are of description which is in the course of seller's business to supply. It is a duty of the seller to supply goods. Such goods are reasonably fit for the purpose. For example, if a person wants to buy the electric car and it is meant for electrical purposes and for electrical charging purpose. In this case, it is meant for exemption apply. And the second one is when goods purchased under patent or brand name. In case where goods are purchased under its patent or brand name, there is no implied condition that goods shall be fit for any particular purpose. Here, the buyer is relying on the particular brand. For example, in India, there are different types of brands are available. When the buyer is very much particular in buying particular brand, in this case, the rule of caveat emptor will not apply. And third exception is goods sold by description. Where the goods are sold by description, there is implied condition that goods shall correspond with the description. It is not so, the seller is responsible. For example, let us take the mobile phone. When the mobile phone is given for the particular description, this mobile phone fulfill the entire descriptions of the particular phone. In this case, this rule of caveat emptor does not apply. And fourth exemption is about the merchantable quality. What is that merchantable quality? When the goods are sold by the merchantable quality, when the goods are bought by description from a seller who deals with particular goods, that description, there is an implied condition that goods shall be of merchantable quality. The rule of caveat emptor is not applicable for the latent defects, but where the buyer has examined the goods, the rule shall apply if the defects were such which ought to have been revealed by ordinary examination. And fifth exemption is goods sold by sample. Where the goods are bought by sample, the rule of caveat emptor doesn't apply if the bulk does not correspond with the sample. And the next one is goods sold by sample as well as description. Where the goods are bought by sample as well as description, the rule of caveat emptor is not applicable in case the goods do not correspond with both the sample and description of either of the condition. And the next one is guilty of fraud, where the seller sells the goods by making some misrepresentation or fraud. The buyer relies on it, or when the seller actively conceals some defect in the goods so that the same could not be discovered by the buyer on a reasonable examination, then the rule of caveat emptor will not apply. In such a case, the buyer has right to avoid the contract and claim for damages. And finally, trade usage. An implied warranty or conditions as to quality or fitness for a particular purpose may be annexed by the usage of trade, and if the seller deviates from that, this rule of caveat emptor is not applicable. Generally, in the ready-made garment businesses, the size of the customers is displayed. Depending on the person's features, the size will be varied. I hope you can understand the rule of caveat emptor.